Welcome to Nasdaq Trade Talks, where we meet with the top thought leaders and strategists in TradFi, digital assets, technology, and financial planning. I'm your host, Jill Malandrino, and joining me on the Market Site desk, we have Frida Polli, CEO and co-founder of Pymetrics, award-winning Harvard and MIT neuroscientist, as well as Keith Sonderling, EEOC Commissioner, and we have Cliff Jurkiewicz. He is Global Strategy and GM of the Customer Advisory Board at Phenom. We're here to discuss new state and local level regulations for AI use in human resources and how organizations can proactively prepare for forthcoming regulations that might vary state to state in the absence of federal law. This year will be pivotal in shaping how AI and HR is rolled out. Many states are replicating parts of New York City's Local Law 144, the only active U.S. law regulating AI for HR. While these laws are developed to put up guardrails, it can feel like a patchwork approach to solving a larger challenge. It is great to have everybody with us. Welcome to Trade Talks. And Cliff, I want to kick this off with you. Give us an overview of the landscape today. Where do AI and HR laws exist, and why are laws pending? What can we expect?
Sure. For New York is, as you said, the only law that's in a compliance period, as we say. But there are at least a dozen states that are discussing legislation to address AI. California, New Jersey, DC, to name a few. You have the European Union that is going to, codify the EU AI, as they're saying, which covers more broadly those laws. But that's the big challenge, is you've got a lot of states working through this problem. And while there are some commonalities in the regulations themselves that we can lean on, I think that not knowing what's going to happen is the real challenge for business right now, because there's a deep scrutiny around AI, and there's no real standard that's been codified to follow. So it's a little bit of the Wild West at the moment, but I think part of that is just this process of how we get to maybe a federal law or some kind of federal legislation.
Frida, why is regulation needed, and why now?
Sure. I mean, I think, look, to Cliff's point, I think it is a bit of a Wild West, and that includes what developers and HR tech companies are doing, right? So while Cliff is correct in saying there's no standard, I mean, obviously there's the federal standard for all employment tools. And I think the reason that these laws are needed in addition to that are multifold. One is that some of them actually are more directed at the vendor. So New York City, you can actually comply at the vendor level, which I think there's an increasing interest in actually regulating vendors, because ultimately they are the ones that have the most input into how these tools are built. And secondly, I think there are places where federal law, again, it was created 50 years ago, has some gaps, and I think these laws are trying to fill those gaps.
So Keith, why is it so fragmented in the states? The EU is able to put together a cohesive piece of legislation, and the second part to that is, do these state laws contradict anything at the federal level?
Well, I just want to start out that there's no misunderstanding that there's laws that apply to AI. Just as at the EEOC, we regulate employment decisions. And what these AI tools are doing is either they're making the employment decision or assisting HR departments in making that employment decision. But at the end of the day, there's going to be an action. There's going to be an employment action, whether somebody's hired, fired, promoted, demoted, et cetera. And that's what my agency has been regulating since the 1960s. And from our perspective, there's no defense to the law if the decision was made by AI or robot. So we look at the employment decision just like we would whether it's made by a human or whether it's made by AI, saying, is there a bias in this decision? Or was this employment decision based upon merit, which is what we look at to make sure that there's no bias in that employment decision. So I think there's a lot of distraction out there with the absence of a global federal AI law, that there's no laws that exist to protect workers or for vendors developing these tools. Right. And that's the misconception I'm trying to change, is that yes, you do have to pay attention to state, local, and foreign governments who are certainly adding on requirements, but at the base, all employment decisions need to be made without bias, that are not discriminatory, and that's how we're going to judge these tools. So whatever the employers are using these tools for, whether it's hiring, promoting, pay, we have an obligation at the federal level to say, hey, there's laws from the 1960s that apply to all of these decisions, whether it's made of technology or whether it's made by human or whether it's made by the next layer of AI we don't even know about yet. However, to your point, there's a lot of patchwork of state and local laws. And for employers who operate at a national level, at a global level, they're going to be in a very tough position to decide, are you going to implement some of the requirements that are coming up, that are already out there? But from my perspective, you still have to comply with the base of federal law, which is going to protect workers wherever you are in the United States, no matter what those additional requirements are.
Yeah.
And Jill, if I might add to what Commissioner Sonderling said, New York City, for example, I know that the regulators, when they were working on that piece of regulation, were very aware of federal law and didn't want to put anything into place that would contradict. And so what does New York City do? It really just, I think, buffers, makes federal law even more relevant in the sense that, essentially mandates disclosure of disparate impact or bias in these tools, which is not something that federal law does, right? But it doesn't contradict in any way what federal standards are in place. And I think that's where, state, local regulation can really be beneficial, is where folks think that potentially maybe gaps is the wrong word, but where these federal laws could be made even more potent, I guess. That's where I think we can see some added benefit. But they don't contradict, or at least the ones that I know of are not in contradiction.
And if you look at what some of these local and state laws are doing, they're adding additional requirements for employers to give transparency, in some cases to give consent to employees, to have some of their rights so they know that they're being subject to this AI tools, which federal law doesn't require. But in a sense, so if you're trying to comply with, like, say, New York, and you're doing pre-bias audit tests, you're doing yearly tests to make sure that the tools you're using do not have bias, then you're also going to be in compliance with federal law because you're eliminating bias before it occurs. So, there are certainly added benefits for employers who operate at a national level saying, New York is requiring us to do this. If we do this, we're also going to be in further compliance with federal law, as almost an added benefit of complying with some of these new requirements states are putting on.
And I think just to add to what both Frida and Keith have said, this is where we are seeing a lot of commonality between what these legislatures are, at least have drafted in their laws. And California has some slightly different language, but ultimately there are some core common elements between all of them around explainability, which you're talking about a little bit, defensibility and auditability, as well as configurability. So those four things are some common high-level threads that you can look to, and if you do comply in those four areas, you are more likely to comply with what these future laws that are going to be in place. So it's actually, don't operate out of fear. It's like, just know what the landscape looks like and start to build your process around.
But on that point, too, you can't lull yourself into thinking, well, I'm complying with New York, so I'm complying with the EU, with federal law. If you look at the New York Local Law 144, it's just doing those testings on hiring and promotion for EEO categories such as race, sex, and ethnicity. Well, the EEOC, we govern A to Z of the employment relationship, more than just hiring and promotions. And we also look at all the protected categories such as age, religion, national origin, different characteristics that may not be required in some of these pre-deployment testing these local laws do. So it's a start, but there's certainly a lot more that federal law is going to continue to mandate. Not in conflict, but just additional things that we look at that cities and states may not feel as important to mandate.
Frida, let's switch gears for a moment here and get into the technology behind it, because I think part of the challenge is when you think of bias in AI, it's very subjective, right? To your point, talking about auditability, how do we quantify, how do we create that baseline of what compliance is? So how is this addressed in HR's AI use specifically?
Well, I think bias as per federal law is really not subjective, right? It's governed by disparate impact. So basically, you're looking at essentially, if men and women are applying, are they getting selected at equal rates? And so there's really a mathematical formula where if 50% of men are selected and 50% of women, that is perfect equality in terms of a decision, versus if you're only selecting 25% of women and 50% of men, that's 0.5. That is well below thresholds for what would be considered bias, right? So just want to get rid of this idea that bias is subjective. It's actually very well defined in federal and local law. And so when we start thinking about how the technology is built and the types of inputs that we would want to look at, I believe that certainly the most sort of progressive companies are doing audits internally of the data sets that they're using is highly critical, right? Because we all know that if you put biased inputs in, you are almost invariably going to produce biased outputs. Pre-testing of your algorithms using this disparate impact framework, testing after they've been deployed. So these are just some, I think, coming to be fairly standard protocols when it comes to anyone that's developing the technology. And so, it really, again, bias is pretty well defined when we think of, hiring, all the hiring decisions that Keith was mentioning.
This might sound like an elementary question, Keith. Is it a one-size-fits-all solution? I mean, geographically, our population makeups are different. New York City is certainly more diverse than, let's call it, rural areas, right? Is it looked at as a one-size-fits-all solution?
And that's where, you know, our agency has a critical mission to make sure that everyone knows that there is no one size fits all when it comes to human resources, when it comes to workplace accommodations or hiring, because as you said, there's a lot of differences. And what we look at is to ensure that employers are doing the right thing, that they're actually out there advertising for jobs based upon the job description of what the employer thinks is necessary for that position. And no other factors come into play. And that's the trickiness of all this, because, you know, if you think about other SaaS software, right? Other software that companies are buying, they're being sold to say, here you go, implement it, you're going to save money, everything is going to be perfect within your organization on the sales side, et cetera. But when it comes to HR technology, because you're dealing with individuals, because you're dealing with civil rights, you know, there's no one size fits all approach. So what we're going to look at is, you just heard about the bias testing that Frida was talking about. We're going to look on it how it applies to that part of your business in that part of the country, looking up at that workforce and to seeing if those skills you're asking the AI to look and to judge and to sort and to filter are actually relevant for the job in that location for that employer, not as an aggregate, but specific to that, to ensure that it's doing its job and it's not improperly excluding people based on protected
Cliff, let's talk about this. What's changing with how businesses approach how they're evaluating and purchasing AI tools?
Sure. I mean, we look at it obviously as a vendor in this area creating these technologies. And I'm just going to build on what Frida said in terms of bias as a start. We think of building in tools into the platform, into our software, into the artificial intelligence and machine learning around bias detection, so that we can understand in relative real time what decisions are being made by human beings as they're working with the technology and ingesting and evaluating, analyzing these recommendations that, for example, AI is making. So bias detection becomes a really big component, as well as testing for adverse impact. So these are actual tools that we build into the platform so that we can assure any one of our clients or any one of the users of our system that they've got the right tools to do exactly what Keith is talking about. Go right down to the job and the individual level and understand the entire auditability of that experience, which we believe is a real benefit, because if you look at the adverse side of that, you know, what did we have to rely on before, which was essentially you're trying to audit a human being's behavior, and that is very, very difficult to do. So there's actually huge benefit to using our tools, because it gives you that audit trail, that defensibility piece. It also helps you understand your business. One of the really big benefits of doing something like adverse impact isn't necessarily because people are making conscious bias decisions. Most of it becomes unconscious because it's just human behavior. But if we can catch that early enough, we have an opportunity to retrain that person, you know, and help them support the organization in a more ethical way.
And Jill, can I just add to that? I mean, I think, you know, Cliff is making several important points. I think that AI, sometimes people shy away from it, but I actually think that it can be infinitely better in terms of personalizing the job requirements for the job and making sure that it's very specific to the company, you know, to the role, to the location. I mean, that's what we found when I was CEO of Pymetrics. Like, we had very personalized algorithms, which, you know, again, is harder to do on a manual basis. And again, to Cliff's point, this automatic testing is also something that, you know, AI platforms can do. And I think another thing just to note, I think the more innovative platforms, you know, those that have come into play in the last, say, 5 or 10 years, honestly are some of the more compliant ones with regulations, because they are newer and they don't have technology debt. And so I think, just to dispel this notion that if it's new and if it's AI, somehow it's going to be riskier or more scary, I don't think that at all. I think they can be uber compliant. And that's what we've seen in New York. I mean, companies like Cliff's, those are the companies that are posting audits. The older pieces of technology that are out there are not. And so what does that tell you? That tells you that these newer platforms really are the ones that are the most able to comply with regulations. So. And
from a law enforcement perspective, which is my agency is a civil law enforcement agency responsible for enforcing these laws. You know, what Cliff made a great point. What are we dealing with now? What have we been dealing with since my agency started in the 1960s? humans. And when somebody doesn't get a job, what do we have to do now? They complain of employment discrimination, our investigators show up, and we say, did you discriminate against this person because of their age, because of their sex, because of their religion? And very rarely does anyone admit employment discrimination. Who would do that? And if AI is carefully designed and properly used, now we have much more transparency than the black box of the human brain. We put so much burden on the black box of algorithms, and we have to understand it. But we haven't done a great job of understanding how humans make employment decisions and if they're injecting their own bias in there or if they're not. But if AI is properly designed, we can actually see, and the employer in a sense can say, we use this tool. Here's the only thing we ask the AI to look at. These are the skills required. And this is why these individuals were selected and these were not. Not because of protected characteristics such as gender, age, sex, national origin, religion, et cetera, but based upon these skills. And that's a much more auditable and transparency than we have now. So that's a different way of looking at this that can really help us disprove discrimination as well.
I'm only laughing because, Keith, I was a former neuroscientist. I can tell you that the brain is the OG of black boxes, and so it's always great to hear someone else make the case that human brains, unfortunately, are far more lacking in transparency than algorithms can be. So,
Cliff, how should businesses, enterprises prepare themselves to be within regulation when it comes to AI and HR?
I think the smartest thing to do right now is to, number one, know that it's coming. Whether it's looking at New York Local Law 144 as the model, EUAI, be well versed in that. I think the other thing that we're seeing that we have a great appreciation for is the businesses that have this foresight are starting to put together governance around artificial intelligence. Very much like if you think of information security, which is something that we've dealt with in the computer age, especially cloud computing, we all go through what's called an InfoSec process when we're working with technologies. I don't think this is going to be any different. I think if you put a structure around AI governance with the right people, with the right focus, it gives you an opportunity to set some standards and guiding principles for the organization that will fall in line with what the current regulatory environment looks like, as well as being able to adapt to that regulatory environment as it moves forward. GDPR is a really good example in terms of data privacy. This is a model that we can use to say, we've been through this already. Right, and so if we look at the reaction response to that, I think AI governance becomes a natural stepping stone into really understanding. So it starts with governance. It starts with getting the right people in the room. I know for Phenom, we've recommended to all of our clients that we want to be a part of that governance with them to help them understand how these technologies are developed, used, maintained, and audited. And so that piece of it, the governance piece, is really important.
It almost sounds like cybersecurity compliance, right? It's kind of along that same track. What's the timeline for this?
The difference here is you're dealing with people's livelihoods. You're dealing with their civil rights. And to everything that Cliff just said, having that self-governance structure, using our long-standing principles. A lot of the testing we've been talking about, the EEOC put out in 1978. And it's as applicable to those tests that were done before to using AI. So a lot of it's out there, companies can be doing it, but it's also on who has access to the systems and ensuring that you can have the most perfectly designed AI, you can have all the right applicant pool, it's diverse, the right people are in there, and then somebody can go in the system and inject their own bias and eliminate older workers and suddenly scale discrimination to the likes we've never seen before. But all that can be prevented by having those structures and governance in place. And to your timeline question, now is the time. Because the products are being used as we speak. Anyone entering the workforce, in the workforce, is going to touch this technology, and it implicates all of their civil rights, which the EEOC has been enforcing since the 1960s.
So the compliance is now, we're not waiting for some sort of approval.
It should have been
or
done
processing
yesterday.
of anything. Right. Okay. So realistically, when will this be on the books? Is my question.
As far as we're going to
with AI compliance.
It's already on the books because it's where I started. It's making employment decisions, and that's what we regulate. AI is just assisting or doing that.
And that's the important distinction that I wanted to make. Final words here, Frida?
Just don't be scared. There are tools that make it absolutely possible to be compliant with all regulations on the books, and just don't be afraid. Just lean into it.
All right, appreciate everyone's insight. Thanks for joining us on Trade Talks, and thanks for joining me from MarketSite. I'm Jill Malandrino, Global Markets Reporter at Nasdaq.